Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner-Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner-Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
What happens if CPS is investigating one parent during a divorce?
When CPS gets involved and they're doing an investigation while the divorce is pending, that's going to have a huge impact on custody and possession and access, depending on what the allegations are that CPS is investigating. So what happens a lot of times, unfortunately, is in a divorce situation, sometimes a parent or a relative of a parent will make a false claim to CPS while the divorce is pending to try to get a leg up on the custody part of the divorce. And what that does, if it's eventually found to be unfounded, it can damage that person who made that false report in their custody fight with the other parent. If, however, it's not a false allegation or someone else has made that allegation or report to the police or to CPS, then it could be anyone who's a mandatory reporter. It could be a child's therapist. It could be a school counselor. It could be a school teacher. It could be a police officer at the school. It could be just about anyone who has a mandatory reporting, or it could be a person that is maybe not even associated with the family at all. But what that does is that's going to cause a lot of headache, period, in the divorce. It's going to, like, whatever the custody agreement is or the custody orders are from the court are at the time that allegation is made and that investigation begins, it kind of puts a halt on the proceedings because CPS needs to find out if these allegations are true. And if the court is already involved, CPS may or may not actually too involved, but they will come and testify at court. They will come and bring additional witnesses that can corroborate their story for the allegations. And so it really can have a huge impact on custody in a divorce.
Is there times that the court is going to be the one that has CPS step in? Or
Yes. And in fact, that is a consideration that I make sure to talk to my clients about before we decide to put a hearing in front of a judge. I have had cases where it's highly likely and almost guaranteed that both parents will test positive for some type of substance, and both parents are trying to get the other person to take a test. And so I do like to warn my clients, if you guys both test positive, it is very likely that the court may call CPS to investigate these allegations. So yes, it is possible. And there's other circumstances, not just substance use. If the court does feel like there is significant child abuse or something that they need to report, then they will also report it.
Yeah, and I've had a case where, probably more than one, where the judge asks, stops the hearing and asks, okay, is there anyone here who can take your child if you are not able to take your child? And if there's not anyone there, then they have called CPS to come up to the courtroom and take the child. And it's horrifying. Because you don't want that to happen in the middle of your case. So it is important, like McKenzie said, that we educate the clients and let them know if they're making an allegation and want to report to CPS, or they want to make an allegation that the other parent is doing something, using an illegal substance or abusing the child. We need to make them aware that one of you has to be a good parent and a safe parent for these children. And if you are doing drugs together, or you are having physical combat with each other in front of the children, that's going to be a problem, because neither one of you is going to win in that situation. And that's going to result that CPS is going to have to be called by the court, unfortunately.
Yeah, and I think on top of that, that's why it's really important for our clients to be honest with us, because if we hear, oh, other parent is using drugs or abusing the children, but you never tell us, oh, I will also test positive for drugs, then our advice to you is going to be very different in each of those circumstances.
Exactly. Yeah.
How does CPS determine which parent is more fit to have custody?
Well, it's not really a CPS determination.
Well, they do have so they're going to do their investigation, and they're going, whatever the allegation is of the abuse, whichever kind of abuse it is, they will have a determination at the end of their investigation, and it will have the alleged perpetrator parent, or maybe both parents, listed, and their outcome will be a reason to believe outcome. That is their confirmation that there was that type of abuse that was reported, or they'll be unable to determine because they weren't able to get enough information, or they're not sure, or there will be a finding of ruled out. And so ruled out means that the abuse was not there. They did not find that the allegation was accurate. There wasn't enough information for them to find that the abuse ever occurred. So that is what CPS's investigation finding will be. And as far as a fit parent, they just want to find a safe parent. So they are going to place the child with the safest parent, the non-offending parent, or the parent who has been ruled out as a perpetrator.
Yeah, so in determining the primary custody of a child, that will be the role of the court, but they will look at CPS's investigations and their findings and a lot of times talk to the CPS caseworker to get their opinions on it. But the person who actually makes a determination is the judge.
So a parent that is coming under investigation, what is something they should do when CPS is coming to their house and doing that investigation? What advice would you give them?
Call an attorney first. Really. I mean, oftentimes you don't know what you don't know. So you don't know what the allegations are. Sometimes the investigator will tell you exactly what the allegations are, and sometimes they will tell you a summary or a part of what the allegation is. And so it is best that you call an attorney and get advice on how to communicate with CPS so that you don't get yourself into a situation that you are going to spend months, maybe years, and thousands upon thousands of dollars in trying to get out of a situation that may have started out as misunderstood.
Can a child tell CPS they don't want to live with another parent, and does that have an impact on a custody agreement?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner-Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to behind the case.
They can tell CPS
Yeah.
that, but unless there's reasons of abuse or something like that, CPS isn't really going to have a voice other than a hearsay testimony that the child has told them that. So, I mean, the proper avenue for that, if the child is old enough, 12 or older, is to talk to the judge, and that would have an impact on custody.
Yeah. And on that, it does have an impact on custody, but I think a misunderstanding that we get from a lot of clients is that if my child goes in and says they want to live with me, the judge has to do that. And that's not the case. The judge just has to take that into consideration when they're making their determination, but it is not a requirement.
And it has nothing to do with them telling CPS.
Yeah.
What age does CPS still investigate? Is there a certain age limit that they go to investigate for child?
CPS is up to 18, or unless they're under a court order with the court. And so the child is still under a child support order. So there's 19 but still in high school. They're going to investigate that, but they're going to investigate all children at least up to age 18.
What mistakes do you see parents make that can hurt them when CPS gets involved in their case?
Not calling a lawyer.
Yeah.
I think that's the biggest problem, because sometimes they're giving CPS a little bit too much information. They don't necessarily need to know all of your skeletons in your closet. CPS is there usually for a specific allegation, and that's sometimes they can get themselves in trouble when oftentimes it is substance abuse and it's the other parent, but then you share, well, I know that they're using this because we used to use this together. Oh, have you now?
Yeah.
So why don't we drug test everybody? And so it can get them into trouble by just not calling an attorney and finding out what you should say or should not say.
Is CPS different than a family study? And can you request CPS to come in or a family study to happen during your case?
Nobody wants CPS in their lives.
Yes.
But if you want a custody evaluation, those can be done through the court.
Yeah,
And
or
so,
a private firm.
well, you could order, the court would order the custody evaluation. It can be done either from the courthouse or a private custody evaluator.
And then what advice do you have for clients that are just going through any kind of divorce or custody battle and CPS is being involved into it?
Call an attorney. I mean, you want to
Yeah.
make sure that you are talking with CPS only with your counsel or with the knowledge of your counsel communicating with the CPS worker. The attorney needs to know what's going on with all aspects of the divorce and custody because CPS is going to play a big part in that. And if you don't keep us involved, we can't help you and get you the best outcome.
Yeah, and CPS cases are so complicated and different from a general case, but it is, and our advice differs in each circumstances. So some clients we will give advice to that we would not give to other clients based on the facts, the allegations, and the pending custody or divorce case.
Yeah.
So it's important to talk to us about what exactly is going on.
Can something that happens from CPS override an existing custody agreement?
Yes,
It can.
It can. It cannot change the court order without the judge coming in and changing, someone coming in and modifying that court order. But yes, it can. CPS, especially if there's not a pending legal matter in place, like there's already a final order, but allegations have been made or a report has been made to CPS regarding child abuse or child neglect. They will put, more times than not, they are going to make sure that that child is safe with that parent and ask the parent to sign what's called a safety plan. And that is an agreement between the parents and CPS and any other supervisors or things like that they may have involved in that safety plan to have either supervised visitation, continued drug testing, whatever that allegation is, to make sure that that parent is safe and that child is safe in that parent's care. So it doesn't change the court order, but if the parties do not follow the safety plan, CPS can and oftentimes will file a modification on their own. They will also try to encourage, if the parties can afford counsel, they will also encourage the party that they believe is the appropriate or safe parent to go ahead and file into the court, because CPS is overwhelmed with true serious emergencies that they do need to get into court for, and their resources are better spent in those very dangerous cases where children are in immediate danger. But if there is a safety plan in place and it's being violated, I have seen CPS trying to encourage the other parent to, if you don't file a modification, then we are going to have to. And that's something that I see a lot.
Yeah.
Is there ever a time that you advise your clients to call CPS?
I have.
Yeah.
I have, because we needed that documentation and we needed it to be an ongoing situation in which CPS and others monitored the situation. And when, that report was made, there was simultaneously another report already being made from another mandatory reporter. So not often. I mean, it's not something we encourage, only if absolutely necessary and you need the resources from that CPS offers as well.
Yeah, I would agree. It's very seldom that I actually advise that, but there are very rare circumstances in which we would.
Yeah, because if the abuse is severe enough, and you're presenting that evidence to the court, one of the questions the judge may have on their own is, well, why have you not reported this to CPS ever? And that's something that, if it's serious enough event, it needs to be documented through CPS and most likely the police as well.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com. That's TUMOLAW.com or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.